Good morning. This is Mr. Smith's on Jamal Fontenot. And sir, you are Jamal Fontenot?
Yes.
And Mr. Fontenot is charged with burglary of a habitation in cause number 24 DCCR 2250. And what is the announcement?
We have received the media judge. He has an appointment with my office this coming Thursday to come view that media. So
Okay.
we can kind of get on the same page about what that looks like. If I could just have a resetting to get the time to
Sure.
do that.
Any issue?
And
Okay.
we do have that offer.
Perfect. All right, I'll just reset. Normal reset. Mr. Fontenot, make sure you go make that appointment so you can look over everything that your attorneys received, and we'll see if we can get an announcement at the next court date. Okay, we'll see you then.
Thank you, Judge.
Thank you, ma'am.
May I have excuse?
Yes. See, Mr. Burbank, you have Renisha Chason. Good morning, ma'am. You're Renisha Chason? And Ms. Chason is charged with 24 DCCR 2351. She's charged with injury to a child, elderly, or disabled individual. And then there's a motion to revoke probation in 1933107. And so I know there's a co-defendant.
Judge, if I may, the co-defendant was actually sentenced to pen time last week.
Okay.
Mr. Nichols was able to take care of that for me
Okay.
last Monday morning, which puts us in a much better position with respect to Ms. Chason. Everything has been going well since she's been out on bond. I have extended an offer that was different from the one that before Mr. Williams pled. So I think we're pretty close here on this, hopefully.
So,
And to be honest with the court, Judge, last week kind of threw me a little bit because of the days and this and that. I just need to talk to her and this will be resolved.
okay, so just a couple weeks.
That'd be fine.
Okay, we'll do about a 2-week reset. Make sure you get in touch with Mr. Burbank, go visit with him about everything, and then we'll get your case taken care of at the next court date. Okay,
And I anticipate, Judge, with the court's permission, a dismissal on that motion when she resolves the underlying case. It was the only thing in the motion.
okay, sounds good. Thank you for being here. Jermaine Young, Mr. Burbank, that's Mr. Hoffpower's case. Good morning, you're Jermaine Young,
Yes, ma'am.
and this is 24 DCCR 0916. Mr. Young is charged with aggravated sexual assault of a child. Mr. Burbank?
Last time we were here, we were waiting for some records. I've received some of them. I need to talk to Mr. Hoffman. Can I just have a short recess, so that I can see if we can? This is getting old. And
It is.
I know that this court does not want to set it until there's a drop dead trial.
Yes, I just want y'all to visit before court day.
Last week, as I say, but
Okay. Ms. Malfino? Any?
I don't have an update additional to
Okay.
that. Judge, if Mr.
Patricia
Hoffman
Benton.
ends up being tied up this week, I'm happy to speak with Mr. Burbank.
Okay, perfect. So I'll just this will be the last reset. It'll be a normal 30-day reset. Give you plenty of time to visit with Ms. Malfino, Mr. Hoffpower. Make sure you visit with Mr. Burbank before that next court date so that y'all have a plan on what to do on your case when we come back, okay? All right, thank you.
Ron. I really appreciate it.
Yes. Did I see Mr. Galmore? Mr. Macon, you have Glenn Hicks, that's a sentencing.
Yes, Your Honor, he's here.
And did you hear me say last reset on that last one of Burbank's? Yeah. Mm-hmm.
Good morning.
Good morning, sir. How are you? Good morning. You're Glenn Hicks. And Mr. Hicks was previously in court. This is cause number 25 DCCR 0369. Entered a plea of guilty to the third-degree felony offense of assault, family violence by impeding breath or circulation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your
Any additions or corrections?
No, Your Honor, I don't think so.
All right, Mr. Hicks, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the felony conviction on your record. And if you successfully complete the probation, at the end, the case gets dismissed. The other side of that, though, is if you violate any condition of probation, when you come back, you could be brought back into court, found guilty of the offense, so you would be a convicted felon, and you could go to prison for anywhere between 2 and up to 10 years. Do you understand?
Yes, ma'am.
I want to make sure you understand that you are also, part of your probation is not to have any contact at all with January Corpus. So I don't know what the status of that relationship is, but it's over if it's not already. She cannot give you permission to violate this order, okay? So she can't say, it's okay, I want to get back together, or anything like that. You cannot contact her in person, you can't have communication on your phone or Snapchat or whatever it is. Do you understand?
Yes.
Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to just have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over all of your paperwork. Good luck to you, sir. Let me just, well, I've already talked to Ashley, so no, you can just make sure he files what he needs. They can get reset.
Hey, Roy, Bill Spencer can go, but here's all the forms
Mr. Rojas, you have John Jones.
on those two.
Good morning, Your Honor.
Good morning, how are you?
Good, how are you?
Good.
Judge, Mr. Jones is not here. We have an offer for dismissal for restitution. I spoke with Mr. Jones on Friday and told him about that. He said he needs about 2 weeks to get that money in. I told him we can come today and ask for the reset, but he had to be here. Got a phone call this morning. I just saw a message right now. He was in the hospital apparently yesterday and he cannot be here this morning.
Okay.
No response, John.
So, his bond, what I'll do, I'm going to forfeit his bond for non-appearance and reset it at 100,000. If he gives you, I need some confirmation that was in the hospital or still in the hospital or
Yes, ma'am.
something. And then I'll recall that, so he needs to get that to you pretty quick.
Yes, ma'am.
Okay, thanks. Desandra Joseph, Mr. Rojas.
She's,
Good morning, you're Desandra Joseph. And this is 24 DCCR 0708. Ms. Joseph is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
we signed a rejection.
Oh, is there something on the tablet? Can y'all check the tablet, please? Great.
Here it is.
Okay. So, again, Ms. Joseph, what you're charged with is a state jail felony offense, and that's from February 20th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment could be between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes,
And I think I'm about to have something, maybe. What? It's gone.
Four different.
Oh, okay, I was about to say, it can't be that. Okay, and so, somewhere there is a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 4-year deferred probation. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. Do you understand all of that?
Yes, ma'am.
Also, I want to make sure you understand that once I put your case on the trial docket, then I won't accept this plea agreement after today. So if there's unless there's a change in some information that your attorney or the state's attorney gets. Do you understand that as well?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, we'll get it set for trial, and Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him. I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Rojas, you're released. Ms. Joseph, if you'll have a seat over here on this side of the courtroom, the clerk will call you up in a few minutes with that information.
Yes, ma'am.
And so do we have it?
Yes.
You got it? Okay.
I forgot that I can't on the last one, but if you just have it.
Okay. Let's see, Teresa Taylor, Mr. Rojas?
Judge, we just found out she's,
Trying to confirm that I'm not able to confirm that tonight.
Okay, and I'll call the district attorney's office, that should resolve our case.
So what I'll do, so this is 23 DCCR 2120. Would you call Teresa Taylor?
Teresa Taylor? No response, John?
All right, I have the bondsman notified us that she is in the Hardin County Jail, and so based on that, I am going to find that she's at large without proper bond. I'm going to raise her bond in this case to $100,000, and then we'll see if she bonds out over there. We'll have a hold on her so we can get her back over here, see what happens. Thank you.
That should resolve this matter for us.
Thank you. And then you've got Anthony Williams. It's a sentencing, Mr. Rojas.
he's here.
Anthony Williams?
Good morning, you're Anthony Williams. And Mr. Williams, this is cause number 24, DCCR 0401. You were previously in court, entered a plea of guilty to evading detention with a motor vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Mr. Smith?
Yes, Judge.
Any additions or corrections?
Not from the state.
No, Your Honor.
All right, then, Mr. Williams, I am going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but I'm going to suspend that and place you on probation for 7 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence, while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, and you could be looking at that 10-year sentence that you were already agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, just have a seat here in the courtroom. Probation will call you when she's ready to go over your paperwork. Good luck to you, sir. Ms. Holmes, you've got Christopher Burkett. All right, you're Christopher Burkett. And Mr. Burkett, this is 25 DCCR 0358. And you're charged with burglary of a habitation. Part of your bond conditions were that you had to have a drug patch put on, and that drug patch has tested positive for cocaine. So, all right, have a seat in the jury box. Let's get them tested. Good morning, you're Gregory Sinclair. And Mr. Sinclair is charged with injury to a child, elderly, or disabled individual, and what is the announcement?
Judge, we're just asking for more time to review the evidence in this case.
State's not posted.
All right, so I'll just do a normal reset. Mr. Sinclair, make sure you stay in touch with Mr. Gallimore. Once he gets all the evidence, you need to go and discovery, go visit with him so that we can try to get an announcement, okay? All right, you're free to go. Ms. Holmes, you've got Caden Jones,
Yes, Your Honor.
2 cases.
Do we have an agreement?
Hang on, let's get her. Good morning. Are you Caden Jones? And this is cause number 24, DCCR 2155 and 2156. Ms. Jones is charged with assault on a peace officer and obstruction or retaliation. And what is the announcement?
Your Honor, we do have an agreement for the obstruction retaliation will be reduced.
Hold on a second. Hold it down. Sir. Go ahead.
The obstruction retaliation will be reduced to a terroristic threat, misdemeanor.
Okay.
And with a dismissal in the assault.
Okay.
And so if we could get some time to get it refiled, it's my understanding it'll be refiled to the 18th and we will. plead on
Okay,
the
so it
18th.
needs a refile, not just a lesser. It's
Yes, Judge, I
different.
think it'll be cleaner that way, and it will still involve language involved in the public service on that terrorism.
Okay. All right. So I'll just do a normal reset.
Okay.
So that should give y'all plenty of time to get it taken care of and not have to come back here. But if anything does happen and that doesn't get taken care of, you'll need to come back here on that court date, okay?
If she'll just come upstairs and provide verification of that next Thursday when she does enter that
Yes.
plea, I'll put this at the top.
Okay, thank you. Thank you, Ms. Holmes.
Yes, ma'am.
And then you've got my Keisha Victoria.
Yes, sir. She's outside. Oh, she's right there.
Mr. Smith on my Keisha Victoria. Good morning. Are you my Keisha Victoria? And this is 24 DCCR 2331. Ms. Victoria is charged with tampering or fabricating physical evidence. And what is the announcement?
Yes, Your Honor. I did have an appointment scheduled with Ms. Victoria, but she missed it. She was not able to get off of work, so I have not met with her.
Okay.
I also realized that I was appointed to represent both her and a co-defendant, so
Okay.
I guess I may need them to sign those waivers. I was appointed to her and Nakia Brandon.
Have you had have you visited with Ms. Brandon?
Mr. Brandon.
Mr.
yes.
Brandon,
And
you've
he was-
already visited with him?
Yes, I visited with him.
Okay, so why don't I do this, just to make it clean,
Okay.
is I'm going to remove you from Ms. Victoria's case, leave you on Mr. Brandon's case.
Okay.
Ms. Victoria will appoint someone else this morning. If you'll just have a seat here in the courtroom, the clerk will call you up and let you know who your new attorney is, okay? All right.
Is that the only co-defendant? Is there only one co-defendant?
No, it's,
Well, there's two. There's
Well, I need to know.
Nakia Brandon and Almeda Miles.
Almeda is in custody. She's already pled.
She pled July 27th.
We don't, it doesn't matter, we need to know who the attorneys are, and just what the names are. It doesn't show up for some reason anymore when there are co-defendants. So, that's okay, y'all take, if y'all will help
And no, it
Kelly,
wasn't me,
please.
'cause I know I didn't represent her. Oh, to appoint the same. Yeah.
Right. Monique Nguyen, Ms. Holmes. Good morning. Are you Monique Nguyen? And this is 24 DCCR 1298. Ms. Nguyen is charged with theft of property. And what is the announcement?
So, Your Honor, we were advised, Ms. Nguyen, there were thefts that spanned over several counties in which she has been given time in certain ones, probation in certain counties. And so I talked with Mr. Coleman in regards to the time that she has served about getting her credit. Look, she was in custody for a year, and she was recently released in May. So we want to get proof of that credit so that we can give her credit for the time on this case.
Okay, so I'll just do a normal reset. Ms. Nguyen, make sure you stay in touch with Ms. Holmes, and then we'll see if we can get your case taken care of at the next court date. Okay? Thank you. You're free to go. Mr. Galmore on Charles Newman. Good morning. Are you Charles Newman? And Mr. Galmore, will your client waive the formal reading of the indictment?
Will, Your Honor.
Mr. Newman, in cause number 25, DCCR 0545, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from November 22nd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Galmore? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation. And it looks like there's a co-defendant's case that would get dismissed based on this plea, correct? Also, do you understand, sir, that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Newman's not
No,
competent?
Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay? We'll see you back at sentencing.
Discovery?
Mr. Galmore, you have your discovery.
I need it. Ms. Victoria?
Two announcements whenever the court.
Yeah, make sure you get him to sign that real quick before he leaves the courtroom. And then I'll call your,
Sign right here. Tomorrow, call him and make an appointment.
somebody. It's outside. Do you have Dustin's thing for me to sign? Kelton Hebert, Mr. Galmore. And you need to get the DA to sign that one before, and then give it back. All right, sir, are you Kelton Hebert?
Yes, ma'am.
And this is 24 DCCR 1498. Mr. Hebert is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Judge, we need one more announcement date. There are some videos. There was a conversation that we located on a video, but haven't listened to it yet. And there may be another video coming from the police, but regardless, I think we can have this resolved next time.
State's not opposed to a recent, Judge. There was some discussions about what, if anything, was on a video, and also a discussion about if there is another video that exists. Judge, the state's not opposed to it.
Okay, I'll just do a normal reset so y'all can get that figured out. Mr. Hebert, stay in touch with Mr. Galmore so that once he gets everything, you guys can go over it and see if we can get an announcement that next court date. Okay, free to go. Mr. Crenshaw, you've got Christopher Street.
Yes, sir.
Good morning. Good morning. Are you Christopher Street? And this is 24 DCCR 2058. Mr. Street is charged with theft of property. And what is the announcement?
Judge, we got a revised offer this morning, and if we could just have one more standard reset, my client needs to come up with a restitution upfront in full, and that is his intent to do that, and I think we can get this resolved at the next setting.
All right, so this will be the final reset. Looks like you were hired back in January, so this will be it. If you get the restitution, great. It'll take care of however y'all, whatever. If not, there needs to be something else that you guys are discussing just in case, okay? We'll see you at the next court date.
Thank you.
And then Guillermo Galvin, Mr. Crenshaw. Good morning, you're Guillermo Galvin, and this is 24 DCCR 2321. Mr. Galvin is charged with driving while intoxicated, third or more, and what is the announcement?
Judge, this is going to be refiled as a misdemeanor, and we have a couple of weeks to get that refile done in the police set in the misdemeanor court, and once that's done, I'll send the paperwork to Ms. Morfino, and she'll submit a dismissal.
All right, so what I'll do a normal reset. That gives y'all hopefully plenty of time to get that taken care of. If everything works out, you don't have to come back to this.
This courtroom moment takes a serious turn when the judge explains exactly what the defendant is risking by rejecting a plea deal. Desandra Joseph is facing a state jail felony charge involving injury to a child, elderly, or disabled individual. The judge makes sure she understands that if the case goes to trial and she is found guilty, the potential punishment could range from 6 months to 2 years in state jail. But there is another option on the table. The district attorney's office has offered a 4-year deferred probation agreement. Joseph has the right to accept that offer, or reject it and take the case to trial. And she chooses to reject it. The judge doesn't pressure her into accepting the deal. Instead, she carefully explains that once the case is placed on the trial docket, the current plea agreement will no longer be available unless circumstances change. That makes this moment especially important. The defendant isn't simply saying no to an offer. She is making a decision that could completely change how the case proceeds from this point forward.
Okay, sounds good. Thank you.
Thank you, Judge.
Morning, ma'am. You're Desiree Kirks.
Yes, ma'am.
And Ms. Kirks, in cause number 24, DCCR 0518, you're charged with the third-degree felony offense of deadly conduct discharging a firearm from February 9th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Kimmler's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year deferred probation, a $500 fine, and you would be required to follow any and all rules of probation. Do you understand what the offer is?
Yes, ma'am.
You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you're found guilty and what your possibilities are or options are if you go to trial. Do you understand?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, and Mr. Nichols, is there any reason to believe that that offer would change or any information you don't have?
I don't see anything at this point, Your Honor.
So, Ms. Kirks, I want to make sure you understand that after today, I will not accept this plea agreement. So if you change your mind later, you could enter a plea of guilty, but it would be to something different or just open to the court. Do you understand?
Yes, ma'am.
All right, and so we will get it set on the trial docket. Mr. Kimmler will begin preparation for trial.
Okay.
All right, you're free to go. And then on Ryan Hodge, Mr. Kimmler. Good morning. Are you Ryan Hodge? And Mr. Hodge is charged in cause number 24, DCCR 1167, with evading arrest or detention with the use of a vehicle. And Mr. Kimmler, what is the announcement?
Your Honor, the state has suggested that perhaps I sit down with Mr. Hodge. He's from out of state. He lives in Oklahoma, and look at the video from this, so he can be perhaps better aware of the circumstances of the case.
I would
But
think
this
that would
time
be important.
He's not prepared to enter a plea.
So here's what I'm going to do. I'm going to reset the case just one time. Mr. Hodge, while you're in town, get with Mr. Kimmler. Y'all figure it out. I want you to take a
Now comes the moment where the decision becomes official. The judge asks Joseph directly whether she wants to reject the plea offer and have her case set for trial. Joseph confirms that she does. At that point, the judge moves forward and begins preparing the case for trial. Her appointed attorney is also released, allowing another attorney to be appointed who can potentially begin preparing the defense more quickly. What stands out here is how carefully the judge handles the decision. The court makes sure the defendant understands both sides. She has the right to reject the agreement, but she also needs to understand that the opportunity to accept that specific deal may disappear once the case moves onto the trial docket. There is no dramatic outburst here. Instead, the tension comes from the consequences of a single decision. A plea agreement can provide one path forward, while trial creates an entirely different set of risks and possibilities. And now that Joseph has rejected the offer, the next chapter of this case will be decided in the trial process. The big question is, was rejecting the 4-year deferred probation offer the right move?